Fixed evidence. Evidence.
It was someone returned with a report that as the addressee refused to receive it, stating that the name of her husband mentioned in the summons was incorrect. B. Boy, Srimati B. Boy, wife of Sri Sham Sarma.
Parking order, the handphone or the summons should be issued with the photograph. It sounds like a lame excuse. How many witnesses have been examined?
Three witnesses.
Three.
It's the party. It's present.
Has been wrongly shown to the sun. Prosecution certificates that after verifying the details of the witness, it required the prosecution certificate assistance of the investigating officer.
Yes, sir.
Prefix for evidence prosecution. Directed at
The IO has communicated with me regarding the address of the witness HB. She said one opportunity to be given for verifying the address this
the last order.
to verify the address of the witness from the IO.
What is this case?
This case is
322.
But again, last day also we received.
But he's a very vital witness. He's the one who lodged the FIR on this
If he is
HB.
vital, then you are not also making him vital by taking appropriate steps.
That's what the IO has
Last
taken.
order was passed on 30/10/2025.
Yes, sir.
When was the last witness examined in this case?
Last witness on the 30th age.
Eight. Charge was framed in which year?
In the 4/3/2025, sir.
Charge.
Charge, charge on the 22nd, 8/2017.
17.
Yes, sir.
How many witnesses have been examined?
4, Your Honor.
In 8 years, 4 witnesses have been examined. And now still you are asking for time to summon the witness.
One more opportunity, Your Honor, maybe give this.
Which cost? We'll give you, but if you don't bring a witness, we'll impose cost on you.
Okay, Your Honor.
All the accused are here?
Yes, sir.
There are 5 accused persons.
Only calling door has expired. Only two.
Swollen to expire? No? Amos Dakar is absconding.
Yes, absconding, yes, sir.
Huh? We declared in there?
Yes, already declared.
Already declared, Scotland law.
Just put there.
White order dated 7/8/2025.
Jamin door. Lakhan? One. Oh, Lakhan is absent. Pinche.
Pinchi Sana,
Pinche is present. Lakhan is absent. Tell Lakhan.
accused Pinchi, this Jam Lindo and Pinchi Sana present. Accused Lakon Sumer is absent. Defense counsel is also present. In the instant case, charge sheet was filed when? When was the charge sheet filed?
29/7/2006.
2006, Your Honor.
In the instant case, charge sheet was filed on 29/7/2006, comma, charge was framed when?
On the 22nd, 8, 2017.
Charge was framed. Prosecution has examined 4 witnesses till date after framing of charge. The last witness in the instant case was examined on
On 4th March 2025,
4/3/2025.
Your Honor.
2025. Thereafter, the prosecution has failed to produce witnesses to stop. On the last day, the prosecution had prayed for time so as to enable the prosecution to get the appropriate address of the witness. This court was pleased to grant time. Again, time, full stop. Today, the prosecution is once again praying for time for taking assistance of the IO to summon the witness. Learned additional prosecutor is also submit that the witness is a vital witness. He had filed the FIR in the instant case. As such, the prosecution may be given an opportunity to produce the witness. To stop. Sufficient time has been given to the prosecution to produce the witness. Matter is pending for almost 2 decades after filing of the charge sheet for trial. The prosecution is given an opportunity. The prosecution is given a last opportunity to produce the witness. If the prosecution fails to produce witness on the next date fixed, necessary order shall be passed. Will impose cost if you feel.
Okay.
Yes. Refix your evidence. Yeah.
Witness is the, who we see.
Who?
FSL. DR number.
What is the significance of an FSL witness here?
There are some contradictions.
Huh?
There are some contradictions that I need to examine the episode.
We are disputing the FSL report.
There are some discrepancies there.
No, there may be discrepancies. Are you disputing the report? Then only will summon.
Yes, yes, yes.
Yes. Next. How much time will take for the FSL?
Okay, much time, yeah.
Huh?
I have only 3 questions here.
Okay. Okay. Yes, immediately. Yes.
Here also one witness, Your Honor.
Okay. Where is the witness?
He's here, Your Honor.
And who is for the defense? What is the charge?
302, Your Honor.
His witness is for what purpose?
He's the eyewitness
He is
as
the
per
son of the deceased, sir.
How old is he
14.
now?
Yes, sir.
He's come with whom?
He's come with his relative, you know.
Yes, sir. And of today I'm going to submit this.
Yes, sir.
And certain judgment I would like to rely in connection with.
Have you heard the matter?
Yes, for the argument.
Regarding the 506 judgments.
What is this matter all about?
Mischief 436 506
436
506 427.
trespass,
Yes,
mischief with fire,
yes,
and
427
that is trespass and
506.
criminal intimidation.
Intimidation.
Who are these accused persons?
These are, they were the headman,
Secretary.
Secretary and chairman.
and chairman of
Chairman.
the village of Bamkamar at that point of time.
What is the case?
The case is that
Yes, PW1. Are you aware about this case?
This is
yes,
So let the prosecution. Are you aware about this case?
this I'm aware of.
And then tell us what is this case. These accused persons, they allege
Allege.
that the victims were into practice of a witchcraft.
Yes.
They were called in a meeting to
They
discuss.
called the meeting.
Thereafter, they were excommunicated. They had those ginger plantations in the field.
Yes.
They were called in a meeting and they were asked to leave the village. When they refused to leave the village, the house was burned down. They were excommunicated. Yes. Yes. Tell us. Tell us what
What
is
is
this?
the-
We'll pass the judgment. We are not keeping any judgment reserved. We'll pass the judgments in the court. Refresh my memory. We had heard this matter on the last occasion, isn't it?
yes, sir.
Yes.
So please refresh my memory. In the meeting, a resolution was passed asking them to leave the village because the villagers suspected that they were
Having terror,
into
witchcraft.
having terror or witchcraft or whatever may be.
Yes. The FIR was filed on
Give us the refresh our memory. Okay.
FIR.
If you're not prepared, we'll take it up. This matter as the last matter.
Yes or no?
We'll take it up as the last matter. We'll dispose it of. Provided we get assistance from them. These judgments are for what?
This is for criminal intimation, 506 judgment.
And then
That judgment is only for that, 506.
what is the punishment for excommunication? Is it an offense?
It is not an offense. As first they allege, it seemed like the accused person in this instant case is not.
All right, let us say that they have excommunicated. Social boycott is an offense.
As per law, there is no provision of law.
Under which penal provisions you can book a person for excommunicating?
IPC is not, as per law, is not no punishment.
With the threat not to come back to the village, of course, it may attract section 506.
So in this instant case, as per records, Your Honor, it seemed like the three accused person is only scapegoat by the police.
Huh?
It's only a scapegoat, as per the record and the evidence of the prosecution witnesses.
No.
So
They had called them for a meeting. There's a minutes of the resolution.
yes, that meeting was called. It is only on the basis that the three ladies orally they have made a complaint to the Dorbars now. So the heads now, as the authorized session person in the Dorbars now, so he just called.
No. Please go through the records. Given an ultimatum that within such and such date you should leave the village.
Yes, Your Honor. Okay, then we'll come to that.
It's not only in the meeting. It was not only.
We'll come to that point, Your Honor.
It was not in the meeting. It was not only to resolve the complaint, but in the meeting you also passed a resolution asking these people, the complainant and the family, to leave the village within a specified date.
So that also, Your Honor, it's not to be accepted because why? As per the on record that the incident occurred on 27 March 2015. However, the FIR was lodged on 2nd September 2015, and that allegation that the headman of the Dorbar Snong, Bangkamar, issued to the victim also in the body of the, which is Exhibit 1 and 2, in the body of that letter as alleged that issued by the Rangba Snong, there was no signature, there was no seal, and provision of law as per section 45 evidence also is not complied with by the house. That also, Your Honor, as per the witness of the.
Just be prepared to use section 34.
So that section.
You may not have done anything. You may have not done anything, but we will also take aid of section 34. In a mob violence, you will never get any direct evidence. If you are there with an intention, common intention, not necessarily you should participate in the offense. Anyway, we'll pass we will not keep it pending. We will not keep it reserved. We refresh. We'll take it up this matter as the last matter. Yes, what we have? May bond.
Yes. When I switched to 313, was informed that the accused person is absent today. He was not keeping well, you know.
Rape case?
No. 307. 302.
Okay. Accused. But this is very old case.
Yes, Your Honor. I will take it on the next day.
Please ensure that he is present on the next date fixed.
Possible.
But why is he absent?
He's not keeping well, Your Honor.
This court has been informed by the defense counsel, JP Sariam, that the accused is indisposed today. As such, he could not appear. before this court today, before this court today. The accused shall appear before this court on the next date fixed for the purpose of his examination under section 313. Refix for examination of the accused under 313. Yes.
Kumar, Duarte, Nami.
Yes. Have we framed charge? Yeah.
No, Your Honor.
Where,
Honor,
what?
I appear on behalf of the accused number 3, Honor.
Who's number 3? Larry Cooper Bank.
Yes,
Yes.
Your Honor.
Is there who's appearing for Nini T. Pakma? And this T. Baman, Dwarki T. Baman.
I'm appearing for the entity Pakma.
And Dwarki T. Baman?
I think Arhin is appearing for.
Yes.
He's in box 3 or not taking evidence.
Sorry?
Yes, yes, sir.
Yes. Yes, yes.
Your Honor, for this accused person to work in Vermont, and he had informed me in the morning that he went to his school being a headmaster, and today is the last day of exam, so he needs to make some arrangement for result. So he'll be coming. He had already left from the school,
Okay.
so he'll be coming.
Let's come to the case.
Yes.
Yes. Yes, yes, yes. Why this matter is fixed today and for what?
So it's today is fixed for government sanction from the prosecution. They have 6 times from the court that the court may be allowed them to some time to seek a government sanction.
All right, that's okay. That's okay. Sanction under section 19
Yes.
of the PC Act.
Yes.
The question is that when the sanction was not obtained during investigation, can the sanction be obtained now?
That question, it has been we have discussed it last day, and then the prosecution from their part, they have requested this honorable court to give them some more time to try. So that this honorable court has given them a time, and today is for the report.
All right. Try means we are not trying something in a trial.
Yes. So
We had given them time to seek instruction.
yes.
Whether there is any sanction or where there is no sanction. Now, we can't keep on waiting
Yes.
on the instructions. Admittedly, there is no sanction now. Now, if there is no sanction, charge cannot be framed.
Yes.
What happens to the case?
So see if there's no sanction, so charge we cannot frame, then there's some section is to be tried by the magistrate.
Yes.
Yes.
We have the PCR. We decided now. What is the instruction? Who's appearing for the prosecution?
LS Umbonian.
A discharger.
There
Do
is
you have any authority that we can discharge him in absence of prosecution under section 19, or sanction can be obtained during the course of trial? Do you have authority that we can see sanctions they can produce the sanction during the course of trial? PC Act, let's see. Anyway, who is contending on the sanctions? Some of the accused persons. Who has conceded to the charge?
I think this one accused person is being appeared by this from clear from a reading one. Yes.
Yes, where is your lawyer?
I'm appearing on behalf of Arvar.
Huh?
I'm appearing on behalf on the instruction of Arvar.
Reading one.
Okay, so what do you want to say? What is the instruction on this matter?
there is no instruction, Your Honor,
No instruction.
so far.
He has not abused his, if we don't have the authority to prosecute him under the PC Act
Yes.
and there's no sanction, then what follows? If he is not, what is the charge under the PC Act?
As per section 19, it has to seek the government sanction.
No, what is the charge under the PC Act?
Seven.
If the charge under
Your Honor, the section 19 of this Prevention to Corruption Act says that no court shall take cognizance of an offense punishable under section 7, 10, 11, 12, and 15 alleged to have been committed by a public servant, except with the previous sanction, save as otherwise provided in the Lokpa Yukta Act 2013. So in this case, the section is being charged against the accused person is section 7 and then 13(2). Both it falls under the provision of section 19.
please read the order, the last order. Please read for me also, my last order.
Order dated 28/10/2025. CR Kudakde. Accused persons Srimati Neni Wanda NET Pakma present along with other defense counsel Sri Arwar. Accused persons Sri Do
Come to the relevant part.
Last.
Number 7, the prosecution is given 1 month time to obtain sanction from the competent authority for prosecution of the 3 accused persons. The above order has been passed allowing the prosecution to obtain sanction inasmuch as the trial has not commenced. The case is at the stage of consideration before charge. Number 9, the defense counsel has failed to satisfy this court that at this stage the court cannot allow the prosecution to obtain previous sanction under section 19 of PC Act for prosecuting.
Yes.
Hmm.
Yes. So,
55.
Copy of this order shall be communicated to DIO.
yes. To take fixed form.
Fixed today for production and of sanction by the prosecution.
What is the instruction?
There is no instruction, no instruction here.
Then what are we supposed to do?
Give us one more opportunity, Your Honor.
Why? Yes, he's asking for an opportunity to produce the sanction order.
But Your Honor, 1 month time had been given to them. And moreover, we have been gone through with the drama of this. So even if time is to be given, if the court is to be lenient to them, then a short time to be given to them.
Now we have also posed a question. Who had raised this question of sanction?
Defendant number 2.
No, all of us.
Whether we can grant them time for obtaining sanction. We have recorded that defense counsel has failed to satisfy this court that at this stage the court cannot allow the prosecution to obtain previous sanction under section 19 of the PC Act for prosecuting.
Yes.
We cannot allow them to bring the sanction order now. Do we have any authority to satisfy us that at this stage we cannot give them time, or when the investigation is over without the charge sheet, a charge sheet has been filed without the sanction. Now at this stage, we cannot allow them to produce the sanction order. That question will leave it to accused Nini Wanda Initi Pakma present along with the defense counsel. Who is the defense counsel? S. Dhar. Accused Dwarki T. Baman present along with Rivan R.B. Hing. Accused Larry Kopar Bank present along with the defense counsel Srimati
ADCM, Your Honor.
ADCM. This court, by order dated 28/10/2025, was pleased to grant 1 month time to the prosecution to obtain sanction from the competent authority for the purpose of prosecuting the accused persons under section 9 under PC Act. How much time do you require now?
Two weeks, Your Honor.
In the interest of justice, 15 days time is granted for the prosecution to seek sanction under section 19 of the PC Act 1988. It appears from the prefix for production of sanction order by the prosecution.
Yes, sir.
Good day, Your Honor.
My mother.
I know of the instant case. As the
I know
deceased,
about this thing.
as the deceased is my mother. And I could not recollect the date and month of the incident, but it was in the year 2023.
Here's the accused.
Is present.
The Jaintia check what step more for me.
Ketika Jaintia jaga for thingy ma Yasmin. Yasmin in the evening.
The incident occurred in the evening time. I know Jaintia.
Tinya jaga ketika Jaintia. Yang malam. Tinya. Ti amram tinya. Pam tadong. Tinya ti pam tadong. Dia di Casorok. Casorok jaga. In my house. From pam tadong.
Evening time at our residence.
Ya betul kecenong. Kecenong ketika J. Keram pam tadong. Keram pam tadong. Keram pam tadong.
At our residence, situated at Kram Tadong village, West India. Clear of the mid you.
Kedua mat kelega Smith kelega nyungano ya je. Kuna duduk sedang. Siapa here?
Kenapa ya?
Siapa here? In that evening, we were having our dinner.
On the said day,
Yeah.
in the evening,
Myself,
I,
my brother,
along with my brother,
Yuluti, Chadao.
I, along with my brother, Yumiki,
Yuluti Polong, my step grandfather, and my mother.
Stepfather.
Stepfather.
in the evening, I, along with that.
Ele perbucihi, ele binte ya je.
On the same day, in the evening, I, along with my brother, my stepfather, and my mother, what were they doing?
We were having our dinner.
We were having dinner.
Itu perbucihi, yani kan. Peduk. Kinyak peduk. Kapnum hachu gane, ya kan mama. Akan thap.
It will be loud, it will be loud.
Trong here. Ma, wah, kelu. My stepfather,
Name.
Yatuyum, Amy, Chadao. My stepfather, Amy Taryang.
He's talking about the stepfather who was present there while having the dinner.
Yes.
Oh, my stepfather who was present along with us. What happened?
He took the burning firewood and beaten my mother.
He took from where? He took
Tinyalong ditubu from the
fire area.
from fire area.
They were having dinner where?
In the kitchen, you know, they are having dinner.
Never said that. On the said
Ditubu, no?
I also went, I along with my brother, having dinner in the kitchen. My stepfather, Imi Italian, who was present along with us, took a firewood from the hearth, na? Hearth, na? H-E-A-R-T-H. The pain, na?
Yes, sir.
They write the place where the fire is burned. Took a firewood from the hearth, took a burning firewood. And
The third dal of Gamam,
where, which part?
Tiang Tau Dal, Titumpong, in the neck, you know.
And hit my mother on the back of her neck. Yes.
The Bita Dal of Villa. Then he took my mother to the bedroom.
After she was hit, what happened?
After she was hit, the stepfather took his mother to the bedroom.
What happened to the mother?
Itu dap yang tile ya jiawan. Ya ni gamam. Oh, after he hit her, she became unconscious. Then he took her to the bedroom.
Well, how she became unconscious?
Ya dap yang tile asun ga tepat ketik cu. Te rau pam ya ga au ching di thau thia no. After he hit her with the firewood, she fell to the ground and became unconscious, and then he took her to the bedroom.
Hit my mother on the back of her neck. My mother fell down on the ground and she became unconscious. My father took my stepfather took my mother where?
Di thau thia. Rau ya pat kita haramu rau thau thia no to the bedroom.
Took my mother to the bedroom. Next, after that,
Ya da bita ban ya rau ya di thau thia. On the next morning, he took my mother to the hospital at Nong Talang CHC.
Did he not go and see his mother in the bedroom?
Lamam di thau thia. Ya da dap ya kalau rau ya tu thau thia lamam. Ya lamam ya mam. He went to the bedroom and saw his mother that she was she was severely injured. You know.
Where?
Man mam chow kinyan on the back of her neck.
Did he speak to his mother?
Share mom. No, he didn't speak.
Who took care of the mother whole night?
Kiama kamam broch lama. They three of them, you know.
Huh?
He himself, he took care of mother, his brother, and his bouching and his stepfather. Took care
of the mother whole night. How did they take care of the mother?
Kinya berkomah ya ga man sumar ya ga man. Kinya berkom. They just make her to sleep, you know, and to rest. And on the next morning only they took her to the hospital.
They were there whole night with them.
Sekelang ticu kamera bro selama. Ticu kamera sekelang he. Yes, you know, they were there together whole night with her.
I, along with my brother and my stepfather, we took care of our mother whole night. Did you see the wound of his mother?
Mam nya ijing mong ya ti tutup mam. Mam, he did not see.
Next morning, my stepfather took my mother to hospital at Nongtalang CHC, and then
ya shurti tila lungo pam hakamam di hospital di po nong talang tila si ya dap tila ya bunjia kiya tom. My grandmother informed me that my mother was taken to Yalong CC thereafter.
I was informed by my grandmother that my mother was shifted to Yalong
Yalong
Civil Hospital
no?
for treatment. And then
Ya dap itu ya yarak ya di Yalong yan even. Later, I was informed that a white saliva came out from my mother's mouth. Kaya bentuk ya? Kashlo tambu kali am selang ti tukang. Kaya bentuk ya? Orak ti Yalong. Macam ya? Bentuk padu. He was informed by his padu. Ya tu yung padu he. Lai Lamin, his uncle. He was informed by my uncle.
From my uncle that
Shri ya tu yung Lai Lamin, that white liquid saliva came out from my mother's mouth. Ya ada kita kan? Ya ada bentuk ni ya ada shot tambu kali am selang ti tukang kan? Ya kan? Kinya hadin ono ya ada pilih shot am kan? Tersimbo kenta ni tersimbo singa atau bentuk gimana wasyo. I could not said that when he was informed that the white saliva came out from from her mother's mouth, later he was informed that her mother expired.
I was informed by my uncle that
Boleh cuba sikit? Boleh cuba sikit?
that
and later
what is it? That there was a discharge of white saliva. There was a discharge of white substance, like saliva, from the mouth of my mother. And she expired. Yes.
Jadi kita kan, kita tu mihip doan, ya itu. Let's
Why did the he struck my mother? Suddenly. Yes. Let's take it. They came together to the court today.
La, Mikhail lang, siapa lahir. I came with my uncles to the court.
Where's uncle?
Artinya, Chabaro, Ching, Bandung. He's outside.
He's the one who informed him.
Yes.
He can be inside.
Itu yang mulia, lari lah. Itu.
Yeah, that's all.
I would ask him whether his statement has been recorded by the magistrate.
Ini jing ke Jepang dengan kes da ai tujing kili yang da ai ajing thap tipo magistrate. Fang chulam chane. Tiap malam. Sahab. Yes.
Nice.
I've given my statement. I've given my statement to a magistrate. What do you tell before the magistrate?
Ia kunum agak magistrate lecak malam. Oncom here. Please check the mic. Faham?
Iya.
Hmm.
No.
So he informed the magistrate that his mother was beaten by his stepfather. Then
All right.
she-
I have to give my statement before the magistrate. I state before the magistrate the facts which I have narrated before this court today.
Yes.
Right.
Untuk bikin statement beliau ada MG, beliau ini untuk bertutur.
Mam ini jing thot tina. To ini mo ini kunum hati yang orang itu lalu magistrate. To ha. Yes. Em pernah tanya ke saya ni. Nyai tu yang.
Exhibited as Exhibit 1 and Exhibit 2 will be Exhibit 2 and Exhibit 2 by 1, 2 by 2 and 2 by 3 is my signature.
Itu yang kita dah masuk.
Legend gini apa miat
Nang tu dah keliu yang yatom to ha itu to te ilmu no bab yatom.
Yes, please.
Asim what class did he start? Adu class A for him. Class 2.
I've studied up to class 2. I have studied up to standard 2.
Ask him since when did his father and mother cohabited?
Dang komom naduk dangnya kat segi kamam bucing. Aku nak rekod.
Ask him whether does he remember it has been for around 10 to 5 years.
đã ai thay shipau na satsnam timun ya skelangi oh trong hiện I cannot say.
I cannot recall how long has my mother and my stepfather has cohabited. Has cohabited. And I do not know whether it has been for 10 to 5 years, 5 to 10 years. Ask him whether any police officer had recorded the statement.
Em chỉ còn mo thì police lung statement jing thọ thì em jing kono thì em còn mong kono
So his statement was never recorded in police.
còn mong ha I lung jing thọ police thì em hả lung 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 thì nhận lung
So whether his statement was recorded in his residence or in the police.
my statement was recorded at my residence.
Who had recorded the statement, whether it is a male police officer or female police officer?
Sang kemong tarma mo kon thar police ka lung I jing kono tha
Was he able to communicate with him?
em chu share với em or thu jing thu em chpang ji
Was there any interpreter, or whether any interpreter was present?
sa thom nong man or em chu share với em là ne a ki nong yarap chu kan sa tho em ya tho em
My statement before the police was recorded by a female police officer in my residence, and I do not recall whether the female police officer I do not recall whether there were any interpreter when the female police officer recorded my statement. Asking whether on the day when he was taken to record his statement before the magistrate, who was present along with him?
or lelang hi ti mat ka magistrate he chulung ko jing tho ti hi phang jing je kia lelang bi am kia kia le smu ba he there were many working with me but I cannot recall how many.
I do not.
Ria kemong ria ba kian bakalam apong smu ba nin kemong
Four. Can you ask him? Can you name those 4 persons who were
no
present?
ti tiang ti chipono ki lelang samarem ria ba ki mat magistrate I cannot recall.
You cannot recall. I cannot recall who were present along with me on the day when my statement before the magistrate was recorded. So who took him on that particular day to the magistrate?
Kian kalau mo yang big magistrate. Kian mo yang my uncle. Ya tu uncle tu padum lai lamin. De kiashu lai lamin de kiashu. Ba, ông trong hiểu một sao trong hiểu. Hả? Nhiều lý, nhiều.
Parang
The
female or male?
Tama mo thảo. Tama. My uncle ya tu yung Wenli. My uncle Wenli. Wenli cakap Wenli. Wenli Polo.
And the other person, he said there were 4.
Ai ria bai no. Umi Jalamin, Umi Jet Polong, Tekia ben wi morba. Penuh mo penuh. Nyaka. Yo nyaka. Hả? Shillong. Shillong. Chalang chat out chalang. Chat polong. Đẹp té số mi. Đưa vốn này
On the day when my statement was recorded before the magistrate, uh, 3 persons were present with me, namely 3 persons took me on that particular day, namely Shri Lai Lamin, Shri Wendy Polong, and Shri Chelang Polong. Kindly ask him, since the day of the incident happened in the month of January, according to the records, and the statement which was recorded was in the month of March. So where did he stay on those few months, from January till March?
Nadu ke jingjia ma. Nadu ke jingjia ka mam kile na. Tomut ong imon jia ka tu pununing pang ma. Ya dap wen hadu chu lungi jing thot yam. Nang magistrate amrem lumpor hadu la puno ma. Hadu punu match. Ma jaduri jia ka te yam a jing thom wen hadu tu punu la. Ma punu bala match. No. Te yam nadu li jia hadu chu am jing thom tiang limpor. Ha? Tilong berartinya. Sam sesuatu mau sam di sini. Tangan di sini no.
With whom did he stay?
Dia sam. Padu. I was staying. Yeah, tu yang ni. Lai and Saban. I was staying with Lai Lamin and Saban Tatam.
After the incident happened, I stayed with uncle. His uncle. I stayed with my uncle, Shri Lai Lamin. The other person.
Bagi awan kalau ni Saban Polong.
And with the male fee.
Yatom ya kan? Kadu female wife of.
And my aunt, Shrimati Sawan Polong. At Nongbare.
Nomor no? Nomor ah. Nomor rim.
At Nongbare.
Nomor rim.
Nongbare Rim. So on the day when his statement was recorded, he came all the way from the house of Lai Lamin.
Kalau dengan slow hai kalau culi amra cuti timat magistrate slow hai tisni chong uni padum no chong kadu som tisni tili nomore tili hai. Yes.
On the day when my statement before the magistrate was recorded, I came from the residence of Shri Lai Lamin and Shrimati Sawanpolo. Is it the first time that a statement has been recorded by a magistrate?
Kata to ke ke ano ke siningkong hai lum dia jing thot tiam no ti magistrate kata ke jaran no. Yes.
It is a fact that this was the first time that my statement was recorded before the magistrate. So on that particular day, when he reached the court premises, since it was his first time, he does not know what to state before the magistrate, and since his uncles were present along with him, so it was his uncle who had taught him how to speak inside.
Taman toi kale ko nyunga ka slow hai ni non bole so amno rem ka chulia so magistrate ta ka to ka nyunga ningkong hele slow thale te yam opasa thu hyam ya chu share ya chu khunwa aga magistrate te upadum bigli lang biam khunwa hiam kian chu share taman ta ma kite. Yes.
It is a fact. Since it was my first time, to depose before the magistrate, I do not know what to state. However, it was my uncles who were present along with me on that particular day taught me what to state before the magistrate. Your Honor, with the permission of the court, kindly allow me to confront the witness with the 161 statement. Earlier, he has stated that his statement before the police was recorded. So the statement before the police, in this para, he has mentioned that on the last time when she was physically assaulted by Shri Amy Taryang, he took a piece of firewood and struck her behind her head while they were having an argument. So, however, before this honorable court earlier, he has stated that they had never argued. So if he stated before the police that they had an argument, what was the argument all about?
Yam por yato police biam por lung statement nang nga so nang bare no ong ong uneu ching dar u hagamam daga otma kala ko attachment di radang tene ma por yakhaji agi ong ma por yakhaji agi lu mu to ko tadal ya ma henreven karneven ong to ko otom te a kaching yakhaji ma khaji ong otom te no that was specific.
So since he has stated that they had an argument, what was the argument all about?
Em chu khno kan ne timati pulit ong a ka jinya khaji timati pulit ta he ong o komom ta o tom ta ong snet dat komom ta tipat pulit ong timat pulit bin ong ha ka jing kaje te am chu khno ka ne bha ya kaje ga ka jing kaje bagamam ucing kal ka junga
Okay, so since he does not recall, he was never present on that particular day in that particular room because he has keep on changing his statement.
kaya ni mam ajimut nusar yam satom yam nangnya uam te ordat ucing hakamam uam te dolnya ajimut yam uam te dolnya kaya ni ong ya kajegi dalnya ong ti polis ya kajegi nah ya ti kut ong otom te ya kajegi ya kajegi te satom yam kalau juga uam te tila ordat ya Hah?
But he was taught, yes, he was taught by the, and he was taught by his uncles to
No, it is not
depose
going.
against. Yes, sir.
Last was what?
Yeah, I put a question to him regarding the confrontation of the 161. In the 161, he has stated
Yes,
they
yes.
were having an argument.
Argument,
Now, I asked him, before the police, you stated there were an argument. And before the court, you never stated that they were an argument. So what was the argument all about that you were raising,
No, first
referring?
verify that whether which one is correct, whether he stated that there was an argument, his previous
Okay.
statement is correct or the statement before is correct.
Te da hipulit ong ya kaje i mai pam ya kaje ma ya kaje i mai pam da hia bit kod ong ya kaje te te kanya to ka khonom ti polis i to he a ji kaje mo da hia ong ya kaje te mo ka to ha
Before the police, there were an
da
argument.
hia oto ong
The witness is confronted with the statement under section 164 or 161. What is that part? Quote,
On the last time
comma. On the last time,
that she was physically assaulted by Shri Amy Tarya, he took a piece of firewood and struck her behind her head while they were having an argument.
my statement before the police is correct.
So what was the argument all about that you refer that he's referring here in the statement before the police?
te khu biang yam ya kan mom ya kaje bha ya kaje ucing bagamam le khonom pulin ya khonom pulin bha ya kaje ge
I cannot recall. What was the argument between
Between my mother and
stepfather? Packet accused. Since he does not know the argument, he was never present on that particular day in the room with the accused and the mother.
te satom kan tom bha ya kaje ge yani ya kaje ge the thu sa yam tom to yam kal ku nga ko dat ucing hagamam o am te tilai thao
Since he does not know the argument.
no, you get confused. It is not that he does not know. He cannot recollect.
Yes. Since he does not recollect, he was never present that particular day, but it was his family members who had taught him how to speak against his stepfather.
yang besar agar dia isir sahnya kin churi buriam mo yam kan tom bha ya kaje ucing bagamam mo te yam ong yam satom yam kelinga wam te ordat ucing hagamam satom te yam om te omam te daw ya satom te he said I do not agree
I do not agree that I was not present when my mother and my stepfather was present, was arguing. Uh, can you ask him, does he know the difference between a stick and a fire?
Em chu penya phier có ot có ot mà có ot punishment. Em penya phier. Hả? Em tu penya phier ka có ot punishment và ka có ot hakin. Em penya phier. Em penya phier. Có ot punishment và có ot hakin. Em penya phier itu ngochat. I cannot.
Okay, so you tell him, oh, a stick would be a thin, a long and thin stick, whatever would be
Saya tahu masa có ot punishment, to kalau có ot cái bạn thằng titu jadi jutek, no, kan cie tengah. Cái imi pun chat ot wen di tenang di satu no, ite jing ya phier. Tahu no, có punishment, temu kalau chat tipu tu, the punishment teng cie je pro.
Let's try the first part, no? Whether he knows the distinction between
firewood and a stick.
All right.
I've asked clearly, you know, but he said I cannot distinguish.
All right. I don't know the distinction between a firewood and a stick. Yes.
Also, a stick is where sometimes where fathers used to beat up their children with a stick, and a firewood is used when it's put for use for firewood.
Cái gì phier thì nè, to có ot thằng tu, có ot semen, to boleh thằng tu je pro. Nah, teng chi, no. Te kami pun kecat ot wen, ke badat ucing heyam kalau bom. Kata ke jinga phier. Di thing ya gimana kita gimi chat. Tu teh dui dah na gimi dat. Dili ot isbiat dili ot ikat ne korong ile. Ile tu teh ot thằng tu no. Satu jinga phier to kata. Satu. Có ot thằng tu kami he ka tega ot ke penakam he chu penakam dimi te irukom le chu dat I le chu ai dimi te mi chat ot tu ot thằng tu. Satu kata.
I cannot comprehend. What is that?
The stick and the firewood.
I already said I don't know the distinction between stick and firewood.
Your Honor, I've made an explanation to him that the difference between a stick and a firewood is that a stick.
I cannot comprehend the use of a stick and a firewood.
Ask him whether his mother, prior to the incident, or whether she used to fall sick.
Who am? Prang le jingjia, ma prang le jingjia chu ji ha ka mam ha da du ching ya ka prang le jingjia ba ik chau ka mam. Ba ik chau ka. Yes.
So whenever she falls sick, it was the stepfather used to take care of her.
Ya chau kile te be sumar be ma ching ya no. Yes.
So even you yourself, whenever you fall sick, it was your mother and your stepfather would take care of you.
Ya chau kile ka mam bu ching be sumar ke hi be ma ke no. Yes.
It is a fact. My mother used to fall ill prior to the incident, and it was my stepfather who used to take care of her and me whenever we fall sick. Ask him on that particular day, what was he doing? when the incident happened,
Purjia ke
and where was he?
porli je dan nyama. Yang tinyam be ya nim li por. Skim. Tinya skim. I was sitting in the kitchen.
And where was his brother?
Tinya ubom li por one. Here long.
That's
on
gone.
the-
That's gone.
Yes. Ask him, how did he know that his father took him to Notalang CHC and later to Yalong Civil Hospital?
Yang tinya tom ucing lungo ningkong kamam tipo nang telang idap tiwen ti yalong civil. Kinya tom. Kia pentok yam. Kia pentok yam ha ucing lungo kamam ti nang telang idap tiwen ti civil. Kia pentok yam. Kaduk pentok yam. It was my uncle and my aunt.
It was my uncle. His name?
Lai Lamin.
It was my uncle Shri Lai Lamin and my aunt.
Yaitu yang madum Sawan Polong.
Sawan Polong, who told me that the accused, that my stepfather took my mother to Nong Talang
Yang kan ada orang paling
CHC, Nong Talang CHC, and later to Yalong Civil Hospital. Can you ask him, does he have a phone?
yang pun no.
I do not possess any mobile phone. So is it correct that the mother, the uncle and the auntie told him about where his father, stepfather, had taken the mother to Nong Talang and Civil Hospital after he stayed along with them?
Taman toy mo. Kuno upadum bagamadum yam ucing lungo hostel hakamam tinong telang betipo yalong por isampi igi. Por isampi igi. Huh? Yes.
It is a fact. It was during my stay with my uncle Shri Lai Lamin and my aunt Shri Sawan Polong where they told me about my mother was taken to Nong Talang CHC and later to Yalong Civil Hospital. So it was them who had also influenced him to state against his father before the magistrate.
Is the decision.
No. Ask him.
Taman toy mo. Man upadum bagamadum ong hiyam
Whatever he has stated before the magistrate, it was them who had they had influenced him to state against his stepfather.
taman toy mo. Upadum bagamadum kuno hiyam itu share tipo magistrate iman percha hucing. Taman toy te. Correct.
It is a fact.
Put it again.
Sa dia mijing keling ma. Sikit dimit na, rem dimit na. Ong chong hia. Sa jing ong ma.
And then face this side.
Ma jatuh. Sa share ma. Ka upadum bagamadum kuno hiyam itu share tipo magistrate ma iman percha hucing. Taman toy te. correct.
The uncle
Yes. And the
uh,
auntie.
and the aunt told to speak against his stepfather
Yes.
before the magistrate.
Yes.
Satu non jingkelinga. Thu hiam tomon to ima upadum bagamadum khunu ge hiam hajuang kita timat ke magistrate iman percha houching tomon to kita. It's a fact.
One second. He says that the uncle and the auntie asked him to speak against the
Step.
thing, and he spoke. Did he speak?
To. Upadum bagamadum ong hiam cukunum magistrate iman percha houching. Tiam share ma. Iman percha houching timat magistrate. He said he forgot.
Huh?
He said he forgot. Pilihan, pilihan ong tekan ong pilihan. Inya to.
Did he speak before the magistrate? But his padu and his uncle and the auntie asked him to speak.
Kunum to magistrate. I ong padum bagamadum ma share kita ke magistrate iman persa hucing. Tom to ma upadum bagamadum ong hayam share kita ne iman persa hucing.
Yes. It is a fact.
Huh?
It is a fact.
He spoke. And what the padu and madu said, and he spoke to the thing.
Ya ong bagamadum ya ong upadum hayam share kita tipo magistrate ya ong kita kino. Yes.
So what he spoke with the magistrate is not true.
Hayam ti mat ke magistrate itom ma. Iong hayam. Yes.
Huh?
It is true.
It is true, Your Honor. Whatever they have asked him to speak before the magistrate, he spoke the same.
Yeah, it's all right. We understand that. But then that means what he spoke before the magistrate was not true. It was only tutored by them.
Tamto ima,
See the sequence, huh? We're asking the first question is that whether his uncle and auntie persuaded him to speak against his stepfather. He says yes. Next question. After being persuaded, did he speak before the magistrate as persuaded by the auntie and the uncle? He says yes. Then, what he spoke before the magistrate was being tutored by the uncle and the auntie, and it is not true. It was their version. That is the last question.
yes. Sadam tinama. Kalian juga, kalian syamrem di magistrate, di makla sahab magistrate no.
Show him the papers.
Yang kunum, mamni,
Yang put the signature. How old was he?
most of the report, 12.
Now he's 14.
Karena si most of kat sa 14 yun. Tamto ini sign ni ne. Itam itu yang ne. Toy. Dekat ne, thugu kot hiam ma. Sikit rang dimen. Thugu kot hiam. Yang pak mak sanon, yang saya share. Saya share na. Yang kalau juga, kalau padum yang syamrem. Yang kunum hak magistrate, iya ong padum bang madum. Kunum ite ya ong hiam ma. Iman into ya je bagalagan juga. Tom toy kita. I put to him, Your Honor, whatever your uncle asked you to speak before magistrate did not. It was this. It was not true with what the incident happened.
What was the incident happened till now?
The kuno kat ne, ilai ong temat magistrate ka ong ya kuno gi ya ong padung bermadung cukunum tipok magistrate. Kat ne ya je kalau nyawan. Kuno kan ya je dang nyawan. Ilai mam. Ha?
reality, what did it
Ka
happen?
jing ka
If what he stated before the magistrate is not true, then what is true?
Saat ini mo yo yang satu mam dini upadum bagamadum kuno hiam ong hiam share kita nanti pak magistrate tom toy no te yang kunom ya ong hikit o kunom te ya jia dang lunya takkan yang kuno ko kot ya jia dang lunya ka jing jia senam dang lunya. The reality is that my stepfather has beaten my mother. That's the truth. That's it.
See, this boy is not being able to express himself. He's just saying, "Hoy, Kadai." He's not being able to express himself. Maybe this Pado, his uncle and auntie had told him to speak what he saw. So he's saying that I told things which my Pado and my auntie said. So they might have not tutored. He said, whatever you saw, you tell me. But if he says that they said something
Contrary to the what?
if he was, you see, if the Pado and the uncle and the auntie had asked him to say something which was not true, then what is true? Then he says the truth is that he saw what the Padu and auntie also asked them. See, if the evidence goes this way, we will get no chance to, understand the evidence. It may just give an impression to the presiding officer that, it was all tutored. But he's not being able to express. But prosecution, you don't prepare your witness.
I
You bring the witness just to be tortured in the court.
I tried to communicate with him and explain to him.
No, there's no question of communicate. It's a serious matter. A woman has died.
I understand, John.
You're right. And he's an eyewitness. Get all the missionaries, get in order, get the social welfare department, get the interpreter, get everybody. It's not an empty formality in the court now that somebody will just come and speak and go home. He's a witness, eyewitness to a crime of a murder. So he's not being able to express himself. He's a boy from a village, studied up to class 2. So you need to know how to handle him in the court. He can't be handled like any ordinary witness. Na? You can see his behavior. He's getting more intimidated with the court. He's not being able to express himself. Whatever question is being put to him, he says yes, no, yes, no. He has not explained anything. See, but then your whole cross-examination, it becomes very difficult to put it on record. When he says that his uncle and auntie had told him to speak in the manner they wanted to speak, yes. Did he speak the way the uncle and auntie wanted him to speak? He says yes. So he has spoken the way his uncle and auntie had asked him to speak. So that gives an impression that he's been tutored. But then, if he has spoken the manner in which his uncle and auntie wanted him to speak before the magistrate, that's okay. Then what was the truth? He said the truth was what the uncle and auntie said.
The truth was that my father has hit my mother.
That is what. So what the uncle and auntie asked him to speak? What? If we say that his uncle and auntie asked that you implicate the accused, then understood. Then what is the truth? If they had asked him to implicate, but the truth is that he is innocent or he did not do anything. My mother fell down and got hurt. So nothing of that sort. He's saying the truth is that I saw.
I was going to that cross-examination.
No, that's all right. We understand now because the cross is not going properly now. He's not speaking.
Yes.
He's not speaking. Yes. He is not understanding anything. He's not understanding what is it. What is it? Yes. Now he wants anybody. How he knows how his mother died, and the person who is responsible for killing his mother should be punished.
Do you know? Okay.
He wants how his mother died. He knows how his mother died.
Kamu tahu kaya yip kamam. Yip putih kacau mo, yip putih cadar kamam.
Does he know? Forget about giving and leading any questions to him. Does he know he's 14 years, he's grown enough to understand what is death, what is life? Does he know how his mother died?
Kan dia penjelasan tom kena yip kamam. Dat ya.
Let him express the whole thing. Don't let him answer to it. How his mother died and where did she die?
Kena yip kamam. Kena yip kamam. Kena yip ka. No, he won't. Kena, how did his mother die? Kena yip kamam. Because
Again
of
coming
the,
to Padu.
because of the no, she was beaten. He said.
Huh?
Because she was beaten.
By whom?
Yeah, that. My grandfather.
Grandfather.
Oh, my stepfather. Sorry. Stepfather.
He's here?
Ah, ucing tine. Huh? Tini kamera. Yes, here.
So he doesn't want that the person who was responsible for the death of his mother to be punished?
Kwam uchpro u ata hachu penjip hagamam lano hachu di wujib sistem kwam. He doesn't want.
Huh?
He doesn't want.
Oh, the story ends then.
Oh, kwam ta. Doesn't want.
Huh?
He doesn't want. Oh, kwam hachu pensistem dia. Now he said he wants you.
That's what I'm saying, that he's not being able to understand. There is a serious communication gap. It's not the language.
In sathum jingkalinga om sathum tane ma. Kani dang chubakala ka ya share. Ma. Da sathum jingkalinga kan. Kwam uchpro u pensistem kamam.
See. He's 14 years of his age. This is the first time in his life somebody is asking questions to him, asking him to stand like this and asking him to reply to the questions. First time in his life. I can understand a boy who has studied in school, he may have interaction with the teachers, students, and this questioning and answering becomes part of their life. But he's for the first time standing and being questioned. He does not know what to do. He's, his mind is not prepared. Yes, but he's making if he says that he's been tutored, then the whole evidence falls. Yes, prosecution.
As for today, we'll take time, Your Honor, and we'll let him come and update, Your Honor. Get proper.
We virtually finished.
Here the
After the food is
cross-examination
cooked, he said that give me some time to prepare the food.
Because, Your Honor, whatever I tried to communicate with him today morning, I already explained everything, Your Honor.
No,
Through the uncle.
Please try to understand is that what I'm trying to say, that no matter how much you explain, if you play cricket,
Yes.
you play cricket. Suppose you play basketball. No. If I send you with a basketball in the basketball court, I'm explaining you outside, this is how you dribble, this is how you throw the ball. Can you play? No, it doesn't happen in a day. You'll get more nervous. So it's not one day's job. They need to be prepared very carefully, and you have to bring to our notice that look, the witness is appearing for the first time in the court. He's not very vocal, and he has got some communication problem. His language is also another big problem. So we need to first make him very friendly before he speaks. So in that way, we may take his evidence in the vulnerable positions. And if he just comes like any other witness, he gets more intimidated in the court with the court environment. So he just want to get rid of this place. What is working in his mind that when I'm going to step down and go home, what is happening with me, I don't understand. What is there working in his mind is that just to get down, when this is going to get over, I'll get down and go home. I don't care about what is going to happen to this case. So that is there, and then that is where you need to step in and to see that the witnesses are prepared properly. They are made to feel comfortable in the court. It's only when they are comfortable, then only they will be able to speak. Otherwise, this they will do this.
That's what
A boy who has studied up to class 2,
I understand, but
he will not
this
be able to
morning I did ask him whether he was afraid or not to stand
No,
in the court. He said no, yeah. He said he is comfortable.
always like this at this age, people say they don't want to. Who like to be branded as a coward? If you ask somebody, you are afraid to go to the court. No, I'm never afraid. But come here, they'll collapse here. Who like to say that I'm afraid? Afraid is something which is just a kind of a stigma, not that you are a coward. So they'll say, I'm brave, I can stand there. Can't you make out that he can't speak? Look at his face. Does he not look very stressed? He does not know what's going on. Anyway, but that last part, I'm not very convinced that it is going the way it should go. Your first question says that the uncle and the auntie said to speak the way they wanted him to speak. Then it is followed by the question, did he speak the way his auntie and uncle asked him to speak? Yes, he spoke. Then it automatically follows that he might have spoken the version of the auntie and the uncle. So if the version of the auntie and uncle is different from the reality, so what is the truth? He said the truth is what the uncle and auntie said. He's saying so. The truth is that he saw his mother being beaten up by the stepfather to death. So if the uncle and the auntie says him to tell the truth, so it's not tutor. That is what we can gather from here. But if we just allow the evidence to go on record, by the time the matter comes up for hearing, the argument will be that all his statement under 164 was tutored by the uncle and auntie. Asking a person to speak the truth is not tutoring. Na? But if you ask a person to speak something other than the truth, then that is a mischief. Na? So that part is, of course, if you want to clarify that part, and then we can close it. But we just see, take care of these witnesses. Okay, take care of the witnesses, interact with them. If you find them, see, we are not in a race that we want to dispose of the cases at the cost of sacrificing the case. We are not in any kind of a race. So we can take all time to see that the witnesses are comfortable when they speak. These witnesses, they don't come from very urban area. They are from village. First of all, they get very intimidated. So if they are not very comfortable in speaking in the court, we will take the evidence in the vulnerable witness room. Okay. And you can also observe while examining him in the court. Then you can just say that. So I'm very sorry, but then the witness is not prepared. Witness is not comfortable. So we will allow the witness to be examined when he's prepared. Okay. Don't think that we are, since the witness has come, we will force you to examine him. If it does not help the prosecution case, then let him be prepared. Please do that. Yes.
Yes.
That part is, you see, not going very well. It's the way it ought to go. Is he comfortable here speaking?
Biang sa tampang komisioner lah ya. Awai jing jing ayam. Biang dik rekom.
He wants to sit.
Karena kom juskia. Kom juskia mo yarem.
He's tired.
Cerem. Oh cerem ta. Biang ha sa biang I pran.
He's tired. He's hungry.
Na tampam. Kom juskia.
From where they have come?
Huh? He's fine, you know.
From where they have come?
Dia Islam. Nah ya, dia Islam. Number rib.
Where is this?
It's maybe 6 or 7 kilometers from Amarab.
Oh, what time did they come?
Shimokche pohti
Well, the uncle is here. He can answer him. What time did they come?
Shimokche pohti ne.
They reach here.
11 they reach here.
And what time they left the place?
Shimokche shlo hai. 8:30 they left.
In the meantime, did they have anything?
The porslo hai the buh gaya sarhan. They had breakfast in their home.
At home at 8 o'clock.
Before they left. Shimokche buchi they chai hai. Around 8, Your Honor.
8. Now it's almost 1:30. So young boys, they really feel hungry, na? From 8:30 till 1:30, no food is standing here. The last questions will finish it up. Let him just take a break.
Yes.
Let him take a break. They can go and have something with them.
I have only few questions. Your Honor.
Huh?
Just finish it up. I have only few questions.
Oh, the last question is a very crucial question.
Yes, Your Honor.
If you succeed on the last 3 questions, then that's the most crucial questions.
Yes, Your Honor.
So you can ask those questions if he in the meantime we can examine this one FSL. It's not going to take much time, isn't it?
Just 3 questions.
Let him take a break. He wants to take a break.
Come to
5 minutes, 10 minutes.
1 minute, 2 minutes. Come to kitchen from.
Yes, the uncle will take. But the uncle will not tutor him.
Come to kitchen from 1 minute, 2 minutes.
Take him for some time.
Siap ditempelin di kamar nanti. Come kitchen from.
Okay. Okay, just give him a break for 5 minutes. If they want to, if he's hungry, he can go and have something. Yes. If he wants to have anything, he can just take uncle can take
Yeah,
it.
no, it is also step down. I need to go to work.
Yes, yes. If you a prosecutor wants, you can take him to your room. See, this Lampang, if you want to, you can take him to your room. We have this in our place, the coffee machine working. Then, all right, take them down to our vulnerable witness room, and you can serve them some coffee there. There are some people. Or you can take them. Take them. That's fine.
Madam, can you hear me? Hello? Can you hear me? Yes, madam. Can you hear me? Yes, madam. Can you hear me?
Yes.
Okay. Please take oath. You repeat after me. I swear that the evidence
I swear that the evidence
which I shall give before this court
which I shall give before this court
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me.
Okay, madam. In 2015, where were you posted and in what capacity?
Pardon?
In the year 2015, where were you posted and in what capacity?
In 2015, I was posted as Deputy Director in the Office of Forensic Science Laboratory.
Okay.
Forensic science.
Yes, yes, we got it.
Okay. Presently,
Recently, I retired from service.
I'm retired now.
When she retired?
Which year did you retire?
retired in the month 2022.
I don't have presently. I retired from service in the year 2022.
In connection with this case, what is your role here?
My role is that I examine the exhibits and I furnish the report.
In the instant case, I had examined I had made a forensic analysis.
Forensic analysis.
In this case, I had made a forensic analysis of the exhibits and submitted a report. In the instant case, I had made a forensic analysis of the exhibits and submitted a report. Yes.
When did you receive the exhibits?
The exhibit were received in the office on 15/9/2015 by the then in charge director
Yes, yes.
and was endorsed.
Upon receipt of the exhibit, what did you do?
Well, when I opened the box, the exhibits were packed inside the carton box, wrapped with a white cloth, and sealed with the impression of the seal of SP, West Jaintia Hills, District 01.
Okay. Okay. Carry on.
On opening the box, the following exhibits were found. The exhibits reportedly collected from the victims are: number one, half petticoat marked as EX1. Number two, vaginal swab marked as EX2. Number three, blood sample marked as EX3. Then the exhibits reportedly collected from the accused person are: number one, a jacket marked as EX4. Number two, a white vest marked as EX5. Number three, a track pant marked as Exhibit 6, EX6.
What is the result of your examination?
The result of my examination is after a thorough and careful examination of EX1, EX2, EX4, EX5, and EX6, seminal stain was not detected. Blood stain, which is human in origin, was detected only on EX1, EX2, EX4, and EX5. Blood group A was detected on EX3, EX1, EX2, EX4, and EX5.
Did you prepare any report?
Yes. Yes, that is my report, and that is my signature.
Yes, I prepared a report. And prepare a report dated 5 October 2015 and exhibit and mark as exhibit 11.
Here we got that. Get the cross examination. Yes.
11 by 1 is my signature.
Got the exhibit
Yes.
there with you?
That's all.
You marked it as exhibit?
Yes.
Okay. Let it cross.
Yes.
Hello, officer. Officer, if blood sample of the accused was collected and sent for FSL analysis, whether blood sample of the accused person was collected and sent for FSL analysis.
Yes.
It is a fact that the accused, that the blood sample of the accused person was collected and sent for FSL analysis. Officer, as per your report, you have exhibit 1, 2, and 3 from the victim, while 4, 5, and 6 from the accused person. Is that correct?
Yes.
Yes. However, blood group A was detected in both the exhibit reported collected from the victim as well as from the accused person. Correct? If I may read to you, blood group A was detected on exhibit 3, which belongs to the victim. Blood group A. Exhibit 2, exhibit 4 and 5. 4 and 5 belongs to the accused persons. You clear with me?
Yes.
So the question is it possible for two persons, that is the victim and the accused person here, to have the same blood group? That is blood group A.
It is.
It is possible. My question to you: is it possible?
It is possible. It is possible.
It is possible.
If there is a transfer of blood in.
It is
on
possible.
The
Okay, officer.
On the accused garment.
All right, officer. I agree to the suggestion that it is possible for the two persons, that is the victim and the accused, to have the same blood group.
If the blood is transferred. On the garment of the victim. Yes.
My initial questions was that whether the blood group of blood sample of the accused was collected or not. She said yes.
Yes.
The blood group of the victim was collected. So now whether the two persons blood group were the same, is it possible? Could be the same. So that's my question. It has nothing to do with transfer of blood.
Okay. So that transfer.
The agreed relation that is possible for the accused and victim to have the same blood group. So far as your finding is concerned, I put to you a question, officer. The blood group A that you have detected in all these 6 exhibits, can you determine whose this blood group belongs to?
Yes, because the blood sample of the victim was sent and the blood group was A. So, and this A group was detected on the on her 54.
Yes.
Exhibit 1.
Yes.
And on the vaginal swab, exhibit 2. So the same blood group was also detected on the jacket and the white vest of the accused person.
Officer, the earlier question that I have asked you, whether the blood sample of the accused was collected and sent for referral, and you said yes. So if I may ask you again, what is the blood group of the accused person?
Pardon, because it was not clear, no. The blood of the accused person was not sent in this, along with all these accidents. Only the blood of the victim.
Then so it's possible that for two persons, that is the accused and the victim, may have the same blood group. So my question, other questions to you: can you determine to whom this blood group A belongs to?
I cannot pinpoint, but this blood group belongs to the.
I cannot determine to whom the blood group A belongs
I
to.
cannot determine. The blood group A, which had NLS, belongs to whom?
That's all you know.
But the question number 1 has to be corrected.
It is the fact that was never collected.
It is a fact the blood sample of the accused was collected.
Was not collected.
Was not collected. Yes. That's what.
That is possible. Yes, that's all.
Where is the accused?
The accused is here. You know.
Really? Really? Oh.
Yung kay case here ni. The accused is here.
His name? You with me? What with me? Yeah.
Dining.
Encore me? Yeah.
Dining to change.
Present along with defense counsel. So. Let's put it essential present. Witness. PW. PW. Witness will be PW.
PW11.
Present. They appear to BC from District Court Shillong. Witness examined by the prosecution, cross-examined by defense counsel, witness discharged. Some more witnesses you are examining?
Yes.
Prosecution shall take steps to summon further witnesses.
Your Honor, I would like to mention that the IU listed the fingerprint expert as witness, but it is not helpful for the prosecution. There is no trace of fingerprint in the materials, so I decided to drop him.
PWs will be closed. PWs will be closed.
No. His evidence is not helpful for the prosecution. Some other witness will be.
Means PWs we are not closing. There are some more witnesses.
Yes, sir.
You like to summon.
Would like to summon. But this expert will not help the prosecution, so I would like to drop him.
Okay. Yes. Next, what we have? Yes, sir.
I have one bill application, Your Honor, moving on behalf of the accused person in connection with section case number 10, the Colonel Dakar, Your Honor. It's a murder case, Your Honor, 302.
Will take Monday.
Please.
Where is the prosecutor?
And then you can take leave.
Now we have to bring the record also, na? Record there. Yes, prosecution.
Yes, sign out, okay?
Who is appearing? Yes. If both parties are there, I'll dispose of.
And then we can log out, okay?
I have given the copy to the prosecution, Your Honor.
No, but this is a murder case, so we have to hear both sides. Who's appearing?
Please.
Can we take it on Monday? Monday is what? Monday is first. Well, let's see if we can finish fast.
Small submission only.
Okay, let's see. But matter.
Oh,
The beer matter, what is it?
Please, Your Honor. So this is in connection with session case number 10, 2025. The petitioner here is Colonel Dakhar, age about 35 years, Your Honor. He was arrested on 16/01/2025. You know, the accused here has been in custody for more than 10 months, and he's charged under section 103, bracket 1, whereby the allegations against the petitioner are yet to be proved by the prosecution. You know, if I may highlight that the evidence, the principal prosecution witnesses here, Your Honor, is the wife of the deceased, Smiti Cornelia Aksu, and her minor son, Mr. Nidao Osu. Their statement has already been recorded before this honorable court.
Yes, yes.
Yes. And now the most important and material witnesses in this case, you know, have been examined, admitting any apprehension that the petitioner may influence or tamper with their testimony. You know, it is pertinent to state herein that the evidence placed on record, you know, strongly suggests the possibility of a deliberate and orchestrated plan by the wife of the deceased, that is the PW2, the wife of the deceased, you know, here, to falsely implicated the petitioner here, in as much as in her cross-examination, you know, she had frequently quarreled with the deceased and that the deceased would abuse both her children, and she wished to expel the deceased from the house and to rekindle again relationship with the
Which paragraph?
5, Your Honor.
In cross. PW1.
PW2, Your Honor.
Paragraph 5. In cross examination.
In cross.
Paragraph says that it is not a fact that I and the accused were together in one room. No one was present in the room. Paragraph 14.
Yes.
Yes, prosecution material.
Your Honor, as for this bill, Your Honor, since the vital witness, Your Honor, have already been examined, Your Honor, these eyewitnesses. So, Your Honor, and regarding with this, you know, I have no objection since it's only a bail stage, Your Honor.
This is a bail application. This is a bail application for the. This is a bail application under section 483. Not anything. This is a bail application under section 483 of BNSS, 2023 for the grant of bail to the accused Colonel Dakhar in connection with the session case number 10 of 2025 arising out of which police station?
Camera.
Give the
It
case
will
number.
be fall on Joy. Joy, yes.
Which case? Give the case number. Arising out of Joy PS case number
08/01/2025.
under section 103
103, bracket 1.
1 BNS 2023. The bail application is supported by an affidavit and moved by a legal aid counsel. So and so. LS Kumar, huh? Heard learned counsel. For the petitioner, heard learned additional prosecutor as Lambang. Oh, sorry, T. Learned counsel for the petitioner submits that. Learned counsel for the petitioner slash accused submits strokes accused submits that the accused was arrested on 16/1/2025 in connection with the case number Joy PS case number 8
001/2025
on an allegation that he was involved in causing death of the second husband of his wife. Is it correct?
Yes.
The investigation was concluded in a charge sheet. The investigation concluded in a charge sheet. Charge was framed against the accused on 2nd July 2025. Prosecution has examined 3 witnesses. Learned counsel for the petitioner has brought to the attention of this court the evidence of the witnesses who have been examined only for the purpose of establishing that the accused is entitled to bail. The counsel for the petitioner slash accused has drawn attention of this court to the evidence of the wife, the ex-wife, no?
Yes.
The purported ex-wife. There was no divorce. In this side, there is no concept of divorce. Means once you step on the next step, first step over. Huh? Yes. So, the counsel for the has drawn attention to the evidence of the purported wife of the accused, PW2, to impress upon this court that the prosecution case initially projected accused as a perpetrator of the offense. However, after the evidence has unraveled, it throws light on the prosecution case. The accused, the counsel for the petitioner submits that the accused, on contrary, is a victim of a conspiracy entered by and a conspiracy entered between the wife and the first husband. Stop. On the above ground, the prosecution, the petitioner prays for grant of bail. Another prosecutor does not, in principle, objects to the grant of bail. However, submits that in the event of the accused being released on bail, strict conditions may be imposed protecting the witnesses and ensuring that the accused does not jump bail. Full stop. Next paragraph. The records of the session case number 31 of 2025 is laid before this court. On perusal of the record, it emerges that the accused has been in custody for how many days?
10 months. 10 months.
For 10 months, almost 10 months. This is the first bail application for the accused. The consideration for the grant of bail at the investigation stage is different, and during the trial stage, the consideration for grant of bail during investigation and trial are different. Stop. This is a bail application after the commencement of trial. Vital witnesses have been examined. This court would not like to evaluate the evidence which has come during the course of trial for the purpose of granting bail and attach conclusion. The evidence are examined only for the purpose of coming to a conclusion. If further detention of the accused is necessary, for the purpose of trial, no doubt the offence charge is a very serious offence. However, on perusal of the evidence of the white PW3, without making any comment on the merit, this court is of the view that the accused is entitled to be released on bail. Accordingly, the accused, Colonel Dakar, is enlarged on bail on execution of a PR bond of rupees 20,000 with two sureties of like amount and on the following conditions. Number one, the accused shall appear before this court on the date fixed and stand for trial. The accused shall not tamper with the evidence, intimidate any witnesses, or influence any witnesses. The accused shall not leave the jurisdiction of this court without the permission of this court. The accused thieves are punished is detailed, place of stay, along with mobile number. Bail application stands allowed and disposed of. Where is that order? There's one order. Who is the counsel appearing that the Supreme Court passed an order granting bail?
Family members are here.
Paul?
The working
We have already got it. He's present. This must be trust the lawyers. Once you say that he will come, then we pass the order that he's present.
Yes. Most obliged.
This much faith we have.
For that witness, he said that they will take a rest for some time, take it after that.
See, that's why please try to be a bit smart. Try to understand. No? We are not dealing with some people in the city. When you talk to them, just imagine God has been kind to us that we can speak, we can talk, we can put forward our grievances. But everybody is no fortunate. There are no people. There are no people who can abruptly get up one day and start speaking. Even very exposed people also they have that fear in speaking. And he's a small boy, rather a very young boy, not having experience. Schooling is basically exposing children. You learn how to speak, you learn how to talk. Not about learning mathematics and geography or other subjects. But please be sensitive to them. Otherwise, see the manner in which he was being cross-examined, that was not going correctly. If somebody has to read the evidence later on, who has not recorded the evidence, perhaps there's all possibility that we may go wrong by assuming that the witness was tutored by the uncle and auntie. But he was never it, because the last word he says there, I saw. And he stated before the magistrate also, I saw.
So,
All right.
I'll inform the court when you're ready.
Yes. Yes, tell us what it is orders.
With regards to this order,
Yeah.
I'm waiting for the order to be passed by the Supreme Court so that I can furnish surety.
This one we checked it, the barcode. Barcode we checked. It's coming out this. Yeah. Now this code has been communicated. The joint registrar, bracket listing. Of the High Court of Meghalaya, Shillong, by letter dated 25th November 2025, has communicated the order dated 24/11/2025, passed by the Honorable Supreme Court in SLP bracket criminal diary number NOS 58853/25. Peruse the order of the Honorable Supreme Court. The accused in the instant case has been directed by the Honorable Supreme Court to be released on bail by the trial court on furnishing bond to the satisfaction of the trial court. Stop. The accused is directed to furnish a bond of rupees 50,000 with two sureties of like amount and on a condition that he would appear before this court and any other court and in any other higher court as and when required. Stop. The accused has furnished the bail bond along with sureties. After verifying the documents of the bailers of the sureties, the bail bond is accepted. Issue release notice forthwith. Please explain them.
Mana kami ni albat hawasan, mana kami ni kot ni kan kami kot le habdu kuat. Mohon judi. Tapi,
And if he may be asked to appear for Supreme Court, then he has to appear.
kita kot u apa stas lebih le habdu kuat. Tapi, but they have come through legal aid.
Huh?
They have come through legal aid.
Supreme Court also. Supreme Court also legally.
Yes, there was a report recently.
Hmm.
So we have identified one of all the convicts. So through that only,
He was convicted 302 years.
302 here and then High Court 304 Part 2,
Yes, part 2.
10 years.
Supreme Court admitted.
Yes.
Okay, this is a case of self-defense.
No,
Yes.
this Albert one.
Yes.
They have pleaded self-defense, but they didn't succeed.
Okay. Okay, where are the bills?
I'll just fill up the. Thank you.
But how are they related to them?
Kami talk to Albert Power. His her father and niece and daughter.
Who's the daughter?
She's the daughter.
The daughter?
Yes.
And
She's a niece.
Okay. Good, very good job.
Yes.
And legal aid, of course. Joy only is doing good legally.
What's your right?
Yes, yes. Yes. Then, what do you have? Witness, yes.
Yes, Your Honor. Wait, please, Your Honor. The instant case, in this instant case, the FIR was filed by Srimati Brin Nongrum, Srimati Pirlin Nongrum, and Srimati Stalin Nongrum of Bamkamar village before the in charge PIC Lartiam, that on 27/3/2015, the headman, together with the Dorbar Shillong of Bamkamar village, they chased, expelled her along with her family members to leave the said village as early as possible and also threatened them with dire consequences. Due to fear, she along with
One
her.
second.
Yes.
Who is from Juai? You are from Juai.
Yes, Your Honor.
You are from Juai,
Yes.
from this Jaintia hill.
Yeah.
Please explain me what is this taro?
Taro. See, Your Honor, this taro. Taro is a sort of evil spirits, as per the myth of the Kasi and Jaintia story, or not, that these people who are using to practice or having a tarot, it's like
Hmm?
to protect their own, like if I have a tarot, then if somebody come to my house and steal things,
No, I want to know tarot is something, some object.
tarot is a sort of evil spirits, and these people who used to have tarot, I mean, they used to have a pujas, make a sacrification,
It's
something
good.
like that.
You have
And
tarot is good.
they have their own rule and policy how to respect that tarot.
So what do you do with it?
So that tarot, I means, if somebody come and make something wrong with those people who is having tarot, then that tarot automatically will go and get ill the person who have doing wrong things.
How do you practice this tarot? How do you want to, if I want to,
And not only that, sir, and also, I mean, for those as per the myth, I mean, for those who is having tarot, they use also to, what I mean to say, like whatever they do, they in that tarot used to make them rich, make them to prosper in
tarot
their
is
life.
some mythical person, or tarot is a kind of a practice.
It's a practice, Your Honor, but it's like a kind of evil spirit. So through that practice, we do not know how they practice. They have their own. That is called tarot. And sometime now, for those, I mean, with the passage of time in the present world, I mean, for those who don't know how to practice the tarot in a very proper way, then the tarot is just simply stay somewhere else, and those who, it's like that, sir. That is tarot.
How can you start practicing tarot?
That is, sir, I have no idea. But that
How to
only
end
we
it?
have,
I'm talking about the belief.
because
How do you start
that
it and how do you end it?
that is only is a superstitious belief. However,
Okay.
sometimes as per
Okay.
even in Dubai also, so many people are having tarot as per the saying or hearsay.
Okay.
But the people came to know that, oh, these people are having tarot because that tarot, when she go, and it's like a evil spirit, those people who's having,
Okay.
that's only honor.
Okay. Okay. Yes. Yes, that's it.
Yes, Your Honor.
Hmm.
The FIR in this instant case was filed by Srimati Brin Nongrum, Srimati Hirlin Nongrum, and Srimati Stalin Nongrum of Bam Kamar village before the in charge Ngatiang PIC, alleging that on 20 March 2015, the headman, together with the Dorbar Snong of Bamkamara village, they expel her along with her family members to leave the said village as early as possible, and also threaten them with dire consequences. Due to fear, she, along with her family members, on 4/4/15, shifted to Umrakia village. Again, on the 26/8/2015, they have issued a letter to her that forced her to leave the agricultural land which is situated within the Bam Kamar area. And if she does not cooperate, they will destroy her house and agricultural produce.
Yes.
The FIR dated 1st September 2015 was received at Martian PIC White GD number 4 dated 2/9/2015. It was forwarded to GYPS.
When was the FIR filed?
Uh,
2nd September 2015.
Second,
2nd September 2015.
2915.
Yes.
While the incident occurred on 3rd on 27 March
27,
2015.
27 March.
There was a delay of 6 months, Your Honor.
The FIR was forwarded to JYPS and the same was registered as JYPS case number 190 bracket 9 2015 under section 290 506
Under
427
section
290
JYPS
506
case number
JYPS case number 190 bracket 9 2015 under section 290 506 427 436 slash 34 IPC. And SIW sitting was entrusted with the investigation of the case. The IO in this instant case visited the PO
yes.
during inquiry. The IO stated that at Bamkamar village, it was found that the house belonged to Srimati Brinda Nongrom, left behind unattended, and learned that since 4/4/15, the house owner left the house and found that one plain sheet was damaged by an unknown person, which faced toward the roadside. Also, the house of Srimati Pirlin Nongrum, adjacent to her mother house, was found. Two plain sheets were damaged from the part of the house which faced towards the roadside, as the unknown person have thrown stones. Further, that the house of Srimati Stelinda Nongrum was found, most of the window glass have damaged, and the main door of the house have been burnt by unknown person, and the main door along with nearby windows totally damaged, and the ginger planted in that land nearby the house also damaged by unknown person, around 10 bunches.
Yes.
So the IO recorded their statement. Based on the FIR, these three accused persons were arrested. The IO examined the available witness, that is the informant, complainant, and recorded their statement. During the course of investigation, the IO also seized the proceeding register of Bamkamar Dorbar village in connection with this case. The IO also seized 2 copies of original letters sent to Srimati Brin Nongrom. The IO, after completing the investigation, filed charge sheet bearing CS number 195/2015, dated 27/10/2015, under section 290/506.
290.
290.
90.
290 is not charged. It is
Public nuisance. Causing public
charged
nuisance.
only the 3 sections.
Or charge sheet filed at 2990 or 19?
290, then 506, then 427, and 436/34 IPC. The prosecution in this case examined 8 witnesses altogether in this case. PW1,
One second. Keep it. No charge on the legal. Yes, yes.
PW1,
Hmm.
Srimati Brenda Namrom.
Hmm.
She stated in her evidence that I know all the accused persons standing in the dock today. They are all residents of the village where I stay. The accused Remanut Xier, headman of the Bamkamar village, served me a letter on 26/3/2015, calling upon me to appear in the Darbar of the village on 27/3/2015. Exhibit 1 is the letter. I was summoned by the accused Remanut Xier on an allegation that I was in a witchcraft practice and a lady had fallen ill in the village. That on the following date, in response to the letter issued by the accused Remanut Xier, I went to the Darbar Shnong along with my siblings and relatives at 7 a.m. in the morning. That when I reached the Darbar, the accused Remanut Xier along with the other 2 accused persons at the villagers was there, and the Darbar was filled with the villagers. The village members, along with the accused persons, accused me of practicing witchcraft. I tried to clarify to the members present in the Durbar. I also stated that my parents were born in the village and I am not and I am also a resident of the village. The three accused persons and all the members who were present in the Durbar threatened that if I don't leave the village, they will kill me and my family. I was there in the Durbar of the village for almost 2 hours. That after the meeting at the Durbar was over, I, along with my sister and family members, went back home. I stayed in the village for almost 5 days, and thereafter, I, along with my family members and children, left the village. The house which I stayed in the village was my own house. I left my house as I was put under fear of my life by the accused persons and the villagers. I went to a neighboring village, Rukia, and stayed in my relative house. However, since all of our belongings and agriculture field was situated at Bangkamar village, I used to go to the village, walk in the field, and come back. I never stayed in the village as I feared that the accused persons, along with the other villagers, would kill me. Later on, in the month of August 2015, again I received a letter from the accused Reminot Ksir, and in the said letter, I was warned not to enter in the village, Bamkamar, and further, I was also informed that I have no right over my property in the village. I was also threatened that if I enter my village, they would burn my agricultural field and my house. Exhibit 2 is the letter. Exhibit 2 is the letter received from the man. That 3 days after I received the letter, Exhibit 2, I went to the village, Bamkaman, and found that my house was burned down and my agricultural field where I planted ginger was destroyed by villagers. I reported the matter to Nartiang police station by filing FIR Exhibit 3. Exhibit 3 is the FIR. Exhibit 3 by 1 is my signature. The police arrived, they visited the PO. My statement was recorded by police that I don't stay anymore in the village. I still face threat from the villagers. In our cross-examination, he stated that it is a fact that I was summoned by the Barcelona White Exhibit 1 as there was a complaint against me by three persons, namely Josephine Nongrum, Monica Mukim, and Rebecca Mukim. It is a fact that I was summoned by the headman to decide the complaint received against me by the person mentioned above. It is not a fact that the three accused persons, along with the villagers, never told me to leave the village. It is not a fact that on 27/3/2017, I was not asked to leave the village by the Durbar as the three accused persons. There was delay in filing of the FIR as I have to discuss with my family members before filing the FIR. It is not a fact that Exhibit 2 is a manufactured document as it was served to me by the accused Remunerative. That Exhibit 1 and Exhibit 2 was handed over to the police by my son-in-law, Sri Doris Sayang, who was accompanied me to the police station. It is a fact that from that day I was asked to leave the village. Till date, I am cultivating in the village. It is a fact that I did not see who burned my house and my agricultural field. That the accused person had already threatened me and warned me in burning my house and agricultural field. That is the evidence of PW1. So coming to PW2, Stelin Danango. I received someone to appear before the court today. I know of the case. The incident occurred on 27/4/2015. On the day of the incident, I was at home and I received a notice from the headman Bangkamar village to appear on the next date. at the community hall. On the next day, the meeting was held at the Dorbar Sinong Bangkamar village and decided to excommunicate me and my sister Brinda Nongro, PW1, from the village. And we were forcefully made to leave the village on the same day and went to reside at Lumpia village. On 26/8/2015, I received a warning note that I should not go back to Bangkamar village. On receiving the warning note, my sister Brinda Nongrum, PW1, along with one Sri Rinti Nongrum, went to Nartiang police station to lodge the FIR. And the police went to visit our house at Bangkamar village and found that our house was burned down and the house of my sister, PW1, and my niece, Hirlin Nongrum, was damaged, and our garden, where we used to cultivate ginger, was also destroyed. In her cross-examination, she stated that I don't agree to the suggestion that only Monica Nongrum, Josephine Nongrum, and Rebecca Mukim are involved in excommunicate us from the village, but it is the decision of the entire version of Bamkamar village. It is not a fact that at the time of incident, I was residing at Lumka village. It is not a fact that my sister Brenda Nongong Piduluan was residing at Umrakia village at the time of the incident. I don't agree to the suggestion that only few village members are involved in the instant case, as everything was decided in the village Dorbar. I don't agree that the accused person, Remendos Xier, Gilbert Nongrum, and Edimon Mukim were in jail at that time, where the police found that my house was burned down. It is a fact that I do not see who burned my house. It is a fact that I do not see with my own eyes the person who destroyed my cultivation. It is a fact that till date the house belongs to us and we visit sometimes. It is not a fact that we lodged the FIR against the accused persons who are the headman, secretary, and chairman of the village, as they did not decide the matter in our favor. According to evidence of PW2. Now PW3, Hirlin Mangrum stated that I know of the case. The incident occurred on 27/3/2015. On the day of the incident, I was at home and I received a notice of the headman, Bamkamar village, to appear on the next day at the village Durbar Hall. On the next day, the meeting was held at the Durbar Sinong, Bamkamar village, and did not give us a chance to speak and decide to excommunicate me and my mother, Brinda Nongrum, PW1, and my auntie, PW2, from the village, and we were forcefully made to leave the village on the same day. And I and PW1 went to reside at Umrakia village. My mother requested the village authority not to excommunicate us and to allow us to stay within the village, but they did not listen to my mother, and PW2 went to reside at Lomka village. On 26/8/2015, we again received a warning note that we should not go back to Bamkamar village. On receiving the warning note, my mother, Brenda Nongrum, PW1, along with us, went to Nottingham police station to lodge the FIR, and the police went to.
One second. If people want to have lunch, you can go now. You only tell one of the boys will be here if I need anything. Yes. 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 After receiving a warning.
On 26/8/2015, we again received warning note that we should not go back to Bamkamar village. On receiving the warning note, my mother, Freda Nongrum, PW1, along with us, went to Nottingham police station to lodge the FIR, and the police went to visit our house at Bamkamar village and found that the house of PW2 was burned down, and my house at the house of PW1 was damaged, and the ginger around 1000 kg, which we cultivated, was also destroyed. Exhibit 3 by 2 at Exhibit 3 is my signature. Exhibit 3 is the FIR. In our cross-examination, she stated that I don't agree that Rakia village falls under the jurisdiction of Bamkamar village. It is not a fact that PW2 was residing at Lomka village at the time of the incident. But I want to state that PW2 also have a house at Lomka village. I don't agree that the headman and other members direct us to appear at the Dorbar Hall to adjudicate the complaint lodged by Monica Nongrum, Josephine Nongrum, and Rebecca Mukim against us. It is not a fact that at the time of the incident, I was residing at Umrakia village. It is a fact that I did not see with my eyes the person who are involved in burning down the house. It is a fact that till date the house belongs to us, and at present we cultivate broomstick. I don't agree to the suggestion that only few village members are involved in the instant case, as everything was decided in the village Dorbar, and the notice was handed over to us by the headman. That's the evidence of PW3. PW4, Printores Seriang, stated in his evidence, I know the instant case, the incident
Who is this person? PW4? Son-in-law?
Son-in-law
son-in-law,
PW1.
son-in-law of PW1.
His husband of? Yes, who is the husband of PW3?
So PW1, PW2, PW3 are all female.
No, PW4 is the husband of PW2 or PW3.
No, Your Honor.
Okay, let's see.
Mother-in-law. Brinda Nongkum is my mother-in-law.
That means which he is married to his daughter. Which daughter? Okay, let's see, let's see.
That is not on record.
Hmm.
That is not on record.
Yes, 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 carry on, please.
The incident took place on 26/3/2015, and Srimati Brinda Nongrum is my mother-in-law. My mother-in-law received someone from the headman of Darbar Shillong, Bangkamar, asking her to appear before the Darbar Shillong on 27/3/2015. On the next day, my mother-in-law appeared before the Darbar Shillong, and she was asked to leave the village by giving her 1 week's time. Then on 4/4/2015, which is exactly 1 week from the time given, the entire family of my mother-in-law left the village, Bangkamar, and went to stay at Umrakia village. After 4 months of our settlement at Umrakia village, that is on 26/8/2015, my mother-in-law again received another summon from the Darbar Shillong Bangkamar village, where the Darbar Shillong has threatened that if they return back to the village, Bangkamar, they will be killed. The summon is in the name of my mother-in-law. Thereafter, my mother-in-law, along with me, went to Dapiang PS to lodge the FIR. After the FIR was lodged, the police visited Bangkamar village and found that the house of the sister of my mother-in-law, Srimati Stelinda Nongrum, was burned down and stones were pelted at my mother-in-law's house. I do not know who has burned the house of Srimati Stelinda Nongrum. I do not know who has pelted stones at the house of my mother-in-law. I suspected the headman, Sri Remanus Ksir, Sri Gilbert Nongrum, and Sri Edmund Mukim to have committed the offense since the summon and the threat was received from them. The accused persons, Remanus Ksir, Sri Gilbert Nongrum, and Edmund Mukim, are present in court today. At cross-examination, he stated that Ido Samati Josephine Nongrum, Samati Monica Mukim, and Srimati Rebecca Mukim, and they are four villages at Bangkomar village. I know that Srimati Josephine Nongrum, Srimati Monim Mukim, and Srimati Rebecca Mukim had filed a complaint before the Darbar Shillong against my mother-in-law, alleging that she is practicing witchcraft, bracket tarot. It is a fact that the entire residents of Bamkamar village believe that my mother-in-law is practicing witchcraft. This instant case is arising from that fact. It is a fact that since the allegation, the family of my mother-in-law and the entire village is not harmonious anymore. I agree to the suggestion that because of the allegation, any villagers would have burned the house of my mother-in-law. It is a fact that because of the voice of the people, the family of my mother-in-law had to leave Bamkamar village. It is a fact that my statement was recorded by the police. It is a fact that before coming to the court, I have properly thought of the instant case and what I have not stated before the police, I have stated all before this court. It is a fact that before coming to the court, I have had a discussion with the family of my mother-in-law regarding this case. Now coming to BW file, Linus Nongrum. He stated that I know the instant case. The incident took place on 26, but I could not recollect the month and year as of now. Srimati Brinda Nongrum is my sister. She received someone from the headman of the Darbar Shnong Bamkamar asking her to appear before the Darbar Shnong on 27th, but I could not attend the Darbar as I was not allowed to do so. Later, my sister left Bamkamar village and stayed at Unrukia village. I also saw that the house of my sister was burned down, but I do not know who is responsible for it. Even the ginger plantation were all destroyed. I also saw that there were many stones which were pelted inside my sister's house. Later, the police came to the spot and did the inquiry. They have also inquired from the headman. The police did not record my statement, but I saw that they have taken photographs of my sister's house and also the destroyed vegetation. I know all the accused persons present in the court dock today as they were arrested in connection with this case. They are all so related to me. That's all I have to state. In cross-examination, stated that it is a fact that mischief done to my sister's house and her plantation was because of the allegation by the villagers that she possessed tarot witchcraft and is performing the same on the villagers. It is a fact that the villagers of Bangkamar village already has enmity against my sister as she is having tarot and is practicing it in the village against the co-villagers. I agree that it is the decision of the villagers that has compelled my sister to leave Bamkamar village. It is a fact that I am not properly aware of this case. That is the evidence of PW. Right. PW6 is the Caesar witness. So Frankie BM. Uh, he stated in his evidence that on 2/9/2015, I accompanied SIW shooting where he seized two copies of original letters at the proceeding register of Bamkamar village, Dorbar, and the Caesar list was prepared by the IO, where I have put my signatures on them. Exhibit 4 is the Caesar list bearing EMA number 155/15, dated 27/10/2015. And Exhibit 4 by 1 is my signature. Similarly, another Caesar list in which the two copies of original letters were seized is marked as Exhibit 5, MR number 155/15, and Exhibit 5 by 1 is my signature. The seized materials are brought before the court in packed condition, which is open in the presence of prosecution, defense, and accused persons for identification by the witness. On being shown to me, I state that material Exhibit 1 is the proceeding.
Please get the material exhibits. Please get the material exhibits. Material exhibit 1 and material exhibit 1.
MR 15, 15, 15.
Okay, carry on, please carry on.
Yes. On being shown to me, I state that material Exhibit 1 is the proceeding register of Bamkamar Village Darbar. Exhibit 1 and 2 are the original letters issued by the headman and Darbar Shillong Bamkamar respectively. In cross-examination, it stated that Exhibit 4 and 5 was prepared at Narteng PAC and my signatures were also put at the same place. I signed both Caesar lists on the same day. I was present when the seized materials were made at Exhibit 4 and 5. When the seized materials were made and Exhibit 4 and 5 was prepared. Now PW7 is the investigating officer. He stated in his evidence that in the year 2015, I was posted at Narteng PIC as in charge. I am the IO of the instant case. On 2/9/2015, I received a written FIR from Srimati Brin Nongrum and other of Bangkamar village, White Nartiang, DDE number 4, dated 2/9/2015 at 11:30 a.m. And self has taken up inquiry into the matter, and the FIR was forwarded to the OC JYPS for registering a case under appropriate sections of law. After the officer in charge, JYPS registered the case by JYPS case number 190/9 2015 under section 290/506/427/436/34 IPC. I have been endorsed to investigate the case. During the course of investigation, the PO has been visited and it is found that the house belonging to Srimati Brenda Nongrum left unattended, and since 4/4/2015, the house owner has left the house, and it was found that the plain sheet of the house was damaged by unknown person from the side facing towards the roadside, and also the house of Srimati Khairlin Nongrum was also found that the plain sheet was damaged, has been damaged from the part facing the roadside, as the unknown person has thrown stones into the house. Further, the house of Srimati Stelinda Nongrum was also found damaged from the window, the main door, and the house has already been burned by unknown person. The ginger which was planted near the house was also damaged. Further, all the house owners and the available witnesses were examined, and it is learned the cause of its incident was due to the Bamkamar village people who blamed the house owners that they were practicing witchcraft, and most of the villagers got sick, and the village authority have already expelled them from the village since 27/3/2015. Further, during the course of investigation, Sri Revenus Xier, the headman, Sri Edmund Mukim, the chairman, and Sri Gilbert Nongrum, the secretary of Bamkamar village, were arrested in connection with the instant case and forwarded to the Honorable Court. During interrogation, all the arrested persons stated that after the people of Bamkamar village got sick, and the people who got sick called the name of Srimati Brin Nongrum and blamed that he practiced witchcraft, and the people of Bangkok village pressured the village authority to expel them from the village to avoid any incident in future. Further, during the course of investigation, photographs have been taken at the PO and seized the two sheet of papers produced by the complainant and also a proceeding register of Bamgamar village. I have also prepared the seizure list under MR number 155/15 dated 27/10/2015, marked as Exhibit 4, in which the proceeding register of Bamkamar village Dorbar was seized and Exhibit 4 by 2 is my signature. Similarly, another seizure list in which the two copies of original letters were seized is marked as Exhibit 5, MR number 155/15, and Exhibit 5 by 2 is my signature. On being shown to me the photographs, I state that Exhibit 6 is the house of Srimati Stelinda Nongrum. Exhibit 7 and 8 are the pictures showing broken window panes. Exhibit 9 and 10 are the photographs of the broken and partially burned door leading to the kitchen. Exhibit 11 is the door in which the glasses are shown to be broken. Exhibit 12 is the house belonging to Srimati Pirulin Nangrum, showing that the plain sheet was damaged. Exhibit 13 is the side of the house, showing that the plain sheet has been damaged. Exhibit 14 is the photograph showing the damaged ginger plantation near the house of Stelinda Nongrum. The seized materials are brought before the court in packed condition, which is open in the presence of prosecution, defense, and accused persons for identification by the witness. On being shown to me, I state that material exhibit 1 is the proceeding register of Bam Kamara village, Darbar. Exhibit 1 and 2 are the original letter issued by the headman and Darbar Tong, Bam Kamar, respectively. Under the above facts and circumstances, after observing all formalities, a prima facie case under section 290/506/427/436/34 IPC was found well established against the accused person, Sri Riminus Ksir, Sri Gilbert Nongrum, and Sri Edaman Mukim, and I charge sheeted the case against them and sent them for trial before the court under the aforementioned section of law. The case was charge sheeted by CS number 195/2015, dated 27/10/2015. Exhibit 15 is the charge sheet. Exhibit 15 by 1 is my signature. In his cross-examination, he stated, it is a fact that there was a delay in filing the FIR. From the first incident till the matter was reported to the police, the delay was about 6 months. The first incident took place on 27/3/2015, and the matter was reported on 2/9/2015. It was only 19 to 20 kilometers from the PO to Nartiang PIC. The matter arose as there was a dissatisfaction of the whole village towards the complainant. I visited the PO after 3 days of receipt of FIR. It is a fact that, as per the FIR, the complainant left Bamkumar village on 3/4/2015. It is a fact that there is no eyewitness to the incident. I have not prepared rough sketch map of the PO. The person who produced original copies of letters as per Exhibit 1 and 2 was Sri Dores Sariang. I do not send the two original letters for handwriting expert opinion. It is a fact that There are no signature or seal in Exhibit 1 and 2. I could not remember if material Exhibit 1 has any link with the accused person. No handwriting expert opinion was sought on material Exhibit 1. I have taken photograph on the day I visited the PO. I have taken the photographs with my personal mobile and I extracted it after a long time. I am not sure whether any certificate is required so as to render the photograph admissible as evidence before the court. PWA is also Caesar witness. He stated that I have forgotten about the case as it occurred few years back, but I can identify my signature on Exhibit 4 and Exhibit 4/3 is my signature. In his cross-examination, he stated, I cannot remember where I have signed Exhibit 4. I also cannot remember what was seized. Now, from the evidence of the prosecution, from PW1, PW2, PW3, PW4, it is established that the headman issued a letter to the complainant, informant,
Read Exhibit 1.
yeah,
Read Exhibit 1.
Exhibit 1. Kabrin Nongrom. Kabrin Nongrom. Jong Pam. Da gade ni ai jing tip shapi ba ngala yo mudui naga spin nongrom bat naga Monica Mukim bat naga Rebecca Mukim te kumta la kumta skebha ban one hajir haga 27/3/2015 clampep haga por 6 rubaje step tangkumta pisngeu tho hi uba ai jingtip chupi dei u rangba shnong jongfi. So the headband has issued this notice to appear before the Rabashnom in respect of the allegation that they practice witchcraft.
Then next, Exhibit 2. Exhibit 2.
And Exhibit 2 is Exhibit 2 hak brin nongrum dak ade ngikum ka snong bam kamar i ai jing tip biang supi naduk 26/8/2015 bit chu ban yo kejat ashrong jongi ada gilap yado ladai naka Yeng Jong Pi Pensitom kat kung ka ain snong jongi Pidei ban no sisin don ya ka rep ka riang ka wadai hapo ise jongi bat pidei ro ban no ya u ing jong jong pi ro bat pi one rep ing klem yo jing bit naga snong nadu ba be ya pi ka snong bam kamar Cambridge show ban one rep 100 p one rep bait te kum te ka snong manta ka snong kala pun perksing ya pi ada pim ngai ngin thang do sisen don ya ka yeng jong pi tang kum ta ngai pi las nghèo thu hi ka ba maham ya pi dei ka snong bam kamar this exhibit 2 is the threatening letter issued to PW1
Show me the register. What is the relevance of this material exhibit?
There is no relevance, Your Honor, to this case.
there is no relevancy
There is no relevance. That is only a record.
there is no proceeding on that day
So I object, Your Honor, that exhibit 2.
Yes.
so based on exhibit 1 exhibit 2 it is it is established that is the accused has issued the has issued a warning to the complainant Thereafter, her house were damaged by unknown villagers, which I have read for the prosecution.
Yes, yes,
That's all.
yes, yes,
Shall I start, Your
yes.
Your Honor, reply to the submission made by the prosecution on the allegation that the three accused person before this honorable court had committed of burning the house of the complainant and at the same time destroy the ginger's vegetation which planted in the garden house of the complainant's victim. Your Honor. So, on the basis of burnings of the house and damages the ginger's plantations of the victim, complainant, Your Honor, from the prosecution, based from the examiner-in-chief and the cross-examiner-in-chief of the five prosecution witnesses, which is the families members of the victim, that there is no on record to show or to indicate that they have themselves stated in their evidence that they do not know and they didn't see who burns their house regarding the arson case, Your Honor. It is only because allegation against the accused person before this honorable court, it seems on the basis of surmises and presumptions. Because as per the case that it is only because of the complaint made by these three ladies to the Rangbad orally, then that exhibit 2, the Rangbad now have summoned the victim complainant to the Darbars now with a good intention, Your Honor, to resolve the matter, not with a bad intention to excommunicate or to make any threats against her life, Your Honor. With good intention, the Rangbasna had summoned the complainant and her families on 27 March of 2015. However, unfortunately to say that, and also to say that it's very lucky for the Rangbasna who could control the situation at that time. If he could not control the situation at that point of time or not, we do not know. Maybe it will lead to the family members of the victim complainant to do that also. So regarding this point, Your Honor, I would like to make my submission before this honorable court that from the accused person, from these three accused person before this honorable court, they don't have any bad intention or any ill intention to do such things as alleged them against in this instant case. It seems that they are only make them a scapegoat. It's a scapegoat, Your Honor, because as we have seen that from the 313 of the Rangbasna also, even the people of the village also they have approached him and suspect him and allege him that he is in favor of the complainant and victims. That is very from the statement of the as per the that is as per record, Your Honor. And now these two things, Your Honor, regarding the material exhibits in this instant case to prove the prosecution case, I strongly against because why? The Darbas now to issue the summon or a threatening letter with our signature or with our date given in the bodies of it's not to be accepted in the eyes of lawyer. And also as per law, the law of evidence. The IO from the, I would like to request the Honorable Court to take note as per the cross in the IO clearly indicated or image he did not send for expert or opinion expert. Yes, as per section 45 Indian. And regarding the photographs taken by the IO at the time when he visited the IO, he have stated that I didn't draw the sketch map of the PO, but it is only I took photo with my own mobile phone. That also, Your Honor, for extracting these photographs in the eyes of law or as per the criminal administration of justice, that section 65B is very important. So in this case, just simply on paper, written on paper, then allege the accused person that they are the one who committed of such a big issue is not to be accepted. And regarding the, so on the basis of that, Your Honor, very important evidence also as given by the Pidlifo, who is the son-in-law of the Pidlifo. Even in his evidence, he have stated that why we suspect these three accused persons that they are the one who committed these offenses because they are the one who issued that summon letter to his mother-in-law to appear in the Dorbar Snow of village on 27 March of 2015. It is only because of his presumption and surmise. So presumption and surmise is not the basis, Your Honor, to convict the accused person. Because on record, we have seen, Your Honor, that is, I might say that this is a mob. But it's very lucky, Your Honor, on that particular day that these three accused persons before this honorable court could have managed to control the situation. So on that basis, Your Honor, Section 436, which is an arson case, Section 427, mischief, which means damage the properties or the dangerous vegetation of the complainant victims is not attracted. Because on their evidence, they never, none of the prosecution witnesses with their own eyes who burns their house, who destroy the ginger's plantations. So on the basis of that, Your Honor, the prosecution cannot establish these three accused persons before the honorable court on these two sections, arson case and mischief, and come to the criminal intimation. Criminal intimations, I also, Your Honor, support the honorable court with two judgments, Supreme Court judgment. It says that I don't accept, Your Honor, that these three accused persons before this honorable court have threatened the, if they have such a bad intention, it is on that day itself, Your Honor, that this victim or complainant, we do not know what will be happen to them. Because of their good intention to protect this family, this victim family members, Your Honor. So unfortunately, on that day, nothing had happened. So the law says, or not, the law says, or not, mere threats given by accused person not with an intention to cause alarm would not constitute an offense of criminal intimations. So these three accused persons before this honorable court, Your Honor, they never have a bad intention or the intention to threat this complainant victim in this instant case. So this instant case has falsely implicated these three accused persons before this honorable court. It is only because this incident is to say is a public figures than to set side from the public. Then these three accused persons before this honorable court scapegoats against them as per this case order. So on that basis, Your Honor, I pray this honorable court that there is no case against these three accused persons as a judge. So I pray this Honorable Court, Your Honor, kindly meet them. And from all their liabilities. That is my submission, Your Honor. Because this is very, very important that even the law say that.
You say that those two, exhibit 1 and 2 was not issued by you? You say that exhibit 1 and 2 was not issued by you. You come to your examination under 313. You don't dispute that you had a meeting in the Darbar. If you had not summoned them for a meeting.
No, Your Honor, on the basis of the complaint which I received from those three eco-villages. Yes, I mean, as I'm the, person, headman.
So the meeting was held on 27.
On 27, Your Honor.
So
Yes,
how
we
did
call.
you call them for a meeting?
To resolve the issue, Your Honor. Not an intention to exculpate or to ostracize. We don't have such
What happened
intention. In the meeting, Your Honor, we have tried to resolve the matter and to understand what is the allegation between those three ladies, whether it's true or not. That's only the issue. We call the complainant to attend the.
Why will somebody abandon his house and agricultural field and go to some other village?
No, that.
In the meeting, what happened in the meeting? You tell us, because you admit that there was a meeting.
And I admit that there was a meeting.
So, and these people, these complainants, they say.
I don't know. In the meeting, Your Honor, we from the as the leaders of the Darbas.
No. First, we'll go to the question: is that if there was a meeting?
Yeah.
Did you summon her for meeting?
We summoned her.
How did you summon her?
To appear in the meeting.
How?
How?
Because they have produced the notice. They have produced a notice where they have specified the date, showing that this PW1 was called to appear in a meeting in Darbar through that notice. You admit there was a meeting, but that notice itself is threatening.
We are not at someone meeting. We never nowhere
So you tell us.
Nowhere.
You tell us how did you summon?
We just in the summon letter.
You got your point. But you tell us, how did you summon them for a meeting?
No, because as per that complaint we have given by those three ladies. To understand whether the allegation made by the three ladies against the complainant convicting is true or not.
All right.
So that is the point or the reason we summon her with good intention.
Why did you call for a meeting is different issue. But how did you call for a meeting?
Call meeting, to
resolve them?
To resolve or to know the facts.
That's a different issue. What you wanted to do in the meeting, that is a different issue. The most important thing is that you had called for a meeting. You don't dispute it. You look at your examination under section 313. You are saying that there was a meeting, but we did not excommunicate her. Rather, we wanted to resolve the matter. Isn't it? Now, there was a meeting on 27. How did you call them for a meeting? The witnesses say that, especially PW1, and her evidence is consistent with the evidence of PW2, PW3, PW4, that a local summon was issued asking her to come to the meeting on 27, but the language in which the meeting has been written, the notice was issued, it's not in a good taste. That's one. Second, exhibit 1 and exhibit 2 is only against you.
See, Your Honor, exhibit 1, it's not a harsh language, Your Honor. It is only written like this. Ha kabrindang room. Ha kabrindang room. Da kani nga ajing tip sefi ba ngalayo mudui na ka Josephine nang room but na ka Monica Mukim but na Remika Mukim. Te kumta Sngau bahawan hajiar hag arpenyo terik March 2015 Klempet hag pondru Jamin step. That is not a harsh language.
Exhibit 2. Bring room. With this, we as a Bamkumar village, we again to inform you that on 26/8/2015, all right, are not allowed to set foot on our Bamkumar village. We inform you on 26/8/2015 not to set.
And no. See, I guess from the evidence of the prosecution witnesses only, it have stated that these two exhibits, that means exhibit 1 and 2, have produced or have brought by the complainant only
No,
to the Thana.
not complainant.
It's not as per.
Not by complaint. PW4.
Yes, but I mean, people
PW4
also
is
the
the
family
family.
members of the complainant or not. He accompanied the complainant on the day, I mean, on 2nd September 2015 to the Thana.
But then there is an evidence that the house was burned.
As per lawyer or not, they themselves also told that we do not see with their own eyes. It is only a presumption and a surmises.
It may be a secondary piece of evidence not admissible under law.
So on that basis,
But
Your
it can
Honor,
be used for corroboration.
we are not involved in this somebody, but we are only scapegoat in this instant case, Your Honor.
Tuesday, we don't keep it reserved. Tuesday, this one keep it there. No? Tuesday, we'll deliver it.
All right.
Tuesday.
Your Honor, I seek a permission. If any additional argument from the defendant, kindly.
Please, whatever you want to give before
Yes.
Tuesday, give it.
All right, sir.
Oh, no. You have a person. And this one, then this one will fix it for witness there. Huh? Chalo. Just 5 minutes I'll give. If you take time, then we'll do it some other day. Once time. Yes. This witness, they're going to take time, then we'll continue some other day. We are tired now. We have crossed the lunch time.
I think better refix it because it is his first time coming to court. It's not comfortable.
Yes.
We did not know that it is his first time or either he can speak.
All right.
This and
Fix
that.
for further cross-examination.
Let it be familiar next day.
I don't like it.